Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today we have a special segment wherein we'll be discussing and dealing with two different topics. Yes, that's right. So the first topic that our Amicus for today's session will be dealing is the need for POSH, which is prevention of sexual harassment at workplace compliances with companies, law firms, keeping in mind the significant increase in reporting of harassment cases by interns on social media platforms. And the other topic that the Amicus would be dealing is how to approach recruiters by law graduates, wherein she'll be covering how does one draft an email, how does one approach them, etc. and etc. Now, just to give you all a brief introduction about our first topic, we all are aware of the Vishaka guidelines. These were the guidelines that were promulgated or notified by the Honorable Supreme Court of India, which were intended to protect women at workplace. At that time, the legal system of our country did not have a proper legislation that would ensure the safety of women at workplaces, that provided just and fair punishment to people who indulge in heinous crimes of rape and sexual harassment. And this was done after the infamous Bhavri Devi incident that had taken place. Now, there were a growing number of cases that were reported of sexual harassment and crimes against women, and there was an urgent need for a new set of laws that would punish these wrongdoers. So these set of guidelines basically define what we call as sexual harassment. Now, what is sexual harassment? It could be any physical contact or advances. It could be a demand or request for sexual favors, sexually colored remarks, showing pornography, any other unwelcome conduct, whether it is physical, verbal, or non-verbal. Also provided for a safer atmosphere or a safer working environment. And it also addressed where would that complaint redressal committee be in case if somebody faces this kind of a harassment. So these guidelines were followed by what we call as, or superseded by what we call as, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013, which protects women employees from sexual harassment at workplace. It also defines what an employee is, what actions constitute a sexual harassment. Now, what does a person, employee, or an intern do? Where does he go to report them? Is there an internal committee? Is there an internal complaints committee that would handle it? Is the inquiry that is taking place similar to the one that we see in probably service law, wherein there's a disciplinary committee appointed and there's an inquiry and there's a notice of hearing that is given, etc. and etc. So to elaborate further, we are joined by a very promising young lawyer. She's an advocate and partner at AM Legal Attorneys Gurugram. And just to give you all a brief introduction about our amicus for today's session, we are joined by Ms.Preetika Mishra. She's an advocate at AM Legal Attorneys and in the International and Domestic Commercial Law Division with over 8 years of work experience. She completed her BLLB honors from Rajiv Gandhi National University of Law in 2013 and pursued LLM in International Commercial Laws from University College of London in 2015. Her expertise is in handling complex arbitration, taxation, and commercial law matters involving drafting, review, negotiation on commercial contracts. She had handled extensively legal issues relating to investments in startups in India and overseas, advised clients on various transactions with respect to venture capitals and instruments and other investments. She has represented and advised clients before various commercial dispute redressal forums, National Company Law Tribunal, tax tribunals, international arbitration before SIAC, MCIA, and DIC, involved in a number of multinational corporations on their Indian business ventures. She's also been engaged by foreign law firms to advise on Indian commercial laws. She was selected to serve as project mentor for undergraduate students of School of Law at Singapore Management University for Singapore Convention of Mediation, Comparative Contextual Views. She has also served as mentor for Law Without Walls, a program organized by University of Miami. So thank you so much, Mrs. Mishra, for taking our time. And sorry if we spoiled your Sunday morning. You could have done something productive on a Sunday morning, then to come on our show and give this talk. Anything that you wish to say before we start with our segment?
I think there could not have been a more productive start on the Sunday. So, you cannot take lawyer out of a person now. We have become lawyer by choice. So you have to live by it.
Well, thank you so much there. So we'll be dealing with our first topic. And I think the stage is set. The floor is all yours. Over to you.
Thank you, Jay. So you're very well anyways introduced what the topic is and what the why it came into being and why there was a requirement after all. So before discussing any kind of challenge, so the sexual harassment, which was the issue of discussion at that time when the Vishaka judgment came in, it was very important for everyone to understand the four W's, the rule of four W's, which was why, what, when, and the way out. So, and that goes on for the any kind of legislation or any kind of legal issue that we discuss. So it is very important to have the discussion within the four walls of these four W's. So the sexual harassment in the workplace on women has always been in existence. We cannot deny the fact that there were no cases or there were no cases reported within the companies or in setup, organized or unorganized setup. They have always been there, but it was just unfortunate that we did not have any specific legislation in this particular area which dealt with it until 2013. So therefore, in like you correctly mentioned that Vishakha and others was the state of Rajasthan, which was the judgment that came through which this entire thing changed, the entire dynamics of how these cases would be dealt with in the organization changed. It is very important to, before understand it, what the four basic things that this decision recognized, which people often ignore. So the first thing that was recognized was right to dignity. It was for every profession, occupation, or trade, it should provide a safe working environment for employees. And when I'm saying employees, or when we're talking about POSH and the sexual harassment, discussing it through, I am not just speaking about the women, I am speaking about employees in a very gender neutral manner. So regardless of their choice of orientation they follow, this right to dignity goes for everyone, male, female, or if you choose on to become any other. So this profession, occupation, trade should provide a safe working environment for employees, and it should not hamper the basic right and the basic right to dignity or the basic right to do, just sit in your office and do your work with the dignity. It's just a simple thing. And it's just surprising how this was not there and not part of any legislation until 2013. Then the second thing that was recognized through the decision was right against sexual harassment. Now, women should have the fundamental right towards the freedom from sexual harassment of any kind in the workplace. Now, when we use this term sexual harassment, it's a very broad connotation. It's a very subjective word. So it has a very subjective interpretation in terms of what I understand as sexual harassment compared to what you understand as sexual harassment at your workplace. So therefore, it was very important for these kind of things to be defined and to be put down in a document in a very lucid and clear manner on what would constitute and what would not constitute as sexual harassment. The next thing that was recognized through the decision, very important, was gender equality, which I said that when I'm speaking about sexual harassment, I am not just talking about the women counterparts, I'm also talking about the other genders. So the main objective was to give dignity and respect to the genders across and not just to address this women. We cannot deny the fact that the cases were happening more. The majority of the cases and the majority of the women were subject to such kind of cases, but you also cannot deny the fact, which I would discuss through my talk, how this was also misused at the hand of a certain section of genders. Then the fourth thing that was recognized was need for implementation. Now you've recognized the law, you've recognized the problem, you've already dealt with the three whys and what, why, but how and when, whether, these were the questions which were still to be answered. So that is where the decision became very important, and it harped on the point that this need for implementation, this need to have a proper laid down set of procedures, compliances and process to be followed by all the employers across. So these were the four important things that were laid down through the decision. And this led to the enforcement of the Sexual Harassment of Women at Workplace, the Prevention, Prohibition, Redressal Act of 2013, which we also call the POSH Act. Now, this was enacted and it came in existence since I think December 2013. And the basic rule and the basic objective of this act was to provide, protect, regulate, and create. So it was there to provide a safe environment to women in the workplace and the other genders. It was there to protect the employees against sexual harassments at the workplace. It was there to regulate any misconduct which may eventually lead to a case of sexual harassment. And it was to create awareness to prevent such things from occurring in the first place. So like our laws believe, and we all believe, the prevention is better than cure. So that is where this entire compliance and the set of compliance and the rule and processes came in place. So the idea of speaking today is not to discuss the entire act. However, I would like to touch upon a few important aspects that is important for us to consider while we're discussing these things. Now, the objective we have already discussed, that it was there to protect, provide, regulate, and create. Now, it is very important, which a lot of time when I'm discussing these things with my clients and if I'm discussing these things with the organized setups where the employees, they have a small startups who are coming in. For example, they have a workforce of 10, 11, 12 people. So sometimes they often ask us questions, we are all male, we do not need this. Or they always ask us, we are a very small team of 10 people, do we need these compliances to be done? So it is very important, and there's still a lot of unawareness in the clients, and it is important for us as lawyers and as law firm to provide to cover the awareness part, which the main objective of the act was. So it is very important to understand the applicability of this act. Now it is the act is applicable on any kind of organization. Now, whether you are an organization which is an organized setup, by which I mean that you registered under some entity, registered in an act as a private limited company, or you're an LLP, or you are a sole proprietor, or you are an organized setup where you are a sole proprietor, or you yet to register, or you are under process of registering yourself, whether you're public or private. But if you consist of an employer which are more than 10 employees, this act and the entire compliances have to be done by you. Now, this policies also applies to the employers and employee, irrespective of the gender or position in the organization. The act does not give any exemption, mainly on the basis that you may be a CEO in the company, or you may be a partner in the law firm, or maybe you are an employee who's just the provider staff, for example, the cleaning staff. So it gives no exception whatsoever. And how sexual harassment, like you've already mentioned, how sexual harassment in the workplace has been defined. But that is a very tough job to do on defining this, because I already said it's a very subjective issue. But they've tried to incorporate any kind of demand or request for sexual conduct. So if you, and I'll try and explain this with examples, and these are the real life examples wherein these are the cases we've already dealt with the clients, or they are the cases which has been widely reported. If you go through LinkedIn, after every 10 public posts, there would be a post which is addressing or highlighting a case of sexual harassment at workplace at the hand of an employee or a administrative staff, or anyone who's part of the employee organization, showing pornography, making sexual colored remarks, any other physical, verbal, non-verbal communication by any kind of person in the working organization. So if you see, it has been so widely defined that it also includes a non-verbal communication, which means any kind of enactment, any kind of hand gestures, which may lead to an obscenity, or which may lead to any kind of discomfort to the employer, the person who's working in your setup. That would also be covered in the sexual harassment at workplace. Now, going by the examples, we had cases where the employees, and I'm not going to talk on the gender terms or mentioning who it was or whether it was she or he. So the employee had reported that they had received text at 10 p.m. in the night, at 11 p.m. in the night, sometime at 9 p.m. in the night, wherein one of the staff of the employers was asking them, what are they doing? Are they feeling fine? Why they did not turn up for the work? Or they even ask questions, if they need anything, are they available? Can we meet? Do you want to have coffee? So all of these things, now they are very general communication and question, which is fine between two friends. But you have to see, if you're in a professional setup, you have to see the timings you're messaging. You have to see the group you're messaging at. So something as small, a simple example of this is that um, what can be done now. WhatsApp is the communication where all of these things are happening. So majority of the cases which are reported on LinkedIn, if you study those cases, they were WhatsApp communications wherein the employee from the organization had tried to advance towards the one of the employee in the organization had passed on the advances towards the person or the intern, the victim, as we can say, asking similar kind of question, but at the odd hours. So it's very difficult to define whether this would be covered, this would not be covered. Therefore, it is very important. And the simple thing that can be done is, for example, if you're handling interns and the group of interns who have come in your organization, it is very important. You can have a WhatsApp group wherein which we do in my firm. If I give example from my firm, we have a WhatsApp group, and anytime an intern comes in the firm, the intern is added to the WhatsApp group, and a person from the college, administrative staff from the college, or a person from the placement committee from the college is added on that WhatsApp group, so that there is a third party who is also privy to the communication that is happening. And a very strict instruction is given to the associates and senior associate who would be working or getting assistance from the intern to not communicate anything. Every communication has to be, every kind of email work has to be given through the email, or it has to be passed on the group, the WhatsApp group. No personal communications are allowed. So we have put down those kind of policies in the firm. And even for the interns, there's a very strict instruction that they cannot communicate out of the WhatsApp group whatsoever. And if they're doing that in their personal capacity, then they are the one responsible. The firm is there to handle such cases. We would be happy to address any kind of complaint that may come up. But you have to set some policies in place, some kind of rules in place in order to avoid such situation or leading to such situation. A number of such complaints seen on LinkedIn were the private communication between the employee or an intern or a trainee with a junior staff from a law firm or a private limited company. Now, the issue is that there's always an outside communication, and there's always, because there's no procedure set for these things. We have the number of private limited companies, a number of companies and organizations who have had these rules in place since the act has come. But are we actually practicing on that rule? Are we actually implementing the rule? And if we are not, then it is probably time to put those things at work, because it is a world of social media out there. And if you do not address these things now, it would go out of your hand, and there would be absolutely nothing that you can do about it, because end of the day, you have to protect. These interns could be your future employees. You have to protect them. Now, what workplace includes? Workplace is a primary workplace, which is a registered address of the company. It is an extended workplace. If any employee is traveling related to work, the place can be included in the workplace. So if an employee is going for an offsite, or if an employee is going for some research work, or if your employee or your intern is going to a government office for some kind of filing or some kind of work or some hearing, so all of those will be coming under the extended workplace definition. Then there's a virtual workplace. Now, due to lockdown, the work from home is a new aspect that is now being familiar to all of us. And there have been also cases reported of sexual harassment within this act through the virtual medium. So, and then the work events. Now, the event parties conducted by the company, it can be named as workplace. So the workplace inclusion in the act is very wide. So it basically covers your employees and your the employers and the employees, and anyone who's coming, who may not be employed but who's coming for a shorter role in the organized setup, even that person would be covered. So that is where the interns and every third party is also covered here. Now, what complaint may include? Now, complainant could be any gender who is a victim or the legal hire who can file a complaint with the internal complaint committee. Now, that is where this regulatory body comes in. So under the act, there is a provision for the internal complaint committee, which is required to be formed, and any kind of complaint related to sexual harassment or a discomfort which is being felt has to be duly made to this internal complaint committee, so that you give your employer a chance to resolve this thing. Because it would otherwise be out of your hand, because the act is there and we have to follow the act how it has provided. And the act has very broadly covered all the aspects of how these complaints should be handled, what the internal complaint committee should be, who should be the members of the internal complaint committee. And so much so that there's also an expectation that the people and the members of the internal complaint committee have to be thorough with the act, have to be thorough. They have to undergo the workshops on how to handle these things. They have to also undergo trainings. There's an expectation, there's a requirement for these people to have undergone the trainings in order to handle these kind of complaints. So the complaint committee have to be of a chairperson. There has to be a chairperson who could be a woman working at a senior level as an employee. And if not, then this could be a person who is nominated from an organization or from some other department or of the same employer. A lot of time, people also put a women advocate on the committee to sort of deal and to apprise the complainant and the committee of the legal aspects of things. Then there has to be minimum 2 members on the committee. And there has to be 1 member, like I said, could be a nomination from an NGO, or could be a nomination of the who's familiar with the sexual harassment issues. Now, the function of this internal complaint committee, which we also call ICC, it should be to conduct a free and fair trial. Now, just by the fact that you're a member of the same organization does not give you a right to be biased or to be partial. It has to be a trial which has to be conducted totally transparent and free from any kind of biasness. Then you have to conduct there has to be a training which has to be conducted by this internal complaint committee. And this training could be conducted, you can ideally, this training should be, what we personally feel, this should be conducted from the employees aspect, that employees should be apprised with what your code of conduct related to this policy is. And it should also be conducted for your HRs, who are the administrators within a company, so that they are at all times apprised of what the policy is, so that in case there is a complaint made, then they are able to handle the complaint. They're able to, a lot of time I've also seen where the complaints were made, but they were not handled how the act has provided. They're not even handled or taken seriously, or they were taken as something which was a miscommunication. So this was just, sorted out, saying, no, it may have been a miscommunication. Why don't you try and speak this out, or speak and resolve between yourself? This cannot be our outlook toward these complaints. You have to take it once a complaint is made to an ICC, which is the internal complaint committee. The complaint has to be registered, properly noted in the register which are maintained, had to be conducted with a free and fair trial. There has to be, there should not be any conflict of interest, that has to be managed appropriately. You have to ensure the process has timeline. It cannot just linger on, or it should not then, it should also be confidential. It should not then result. A lot of time, the employees are also scared of putting a complaint to internal complaint committee for the fear of losing their jobs, which is something that is something which is a very ongoing thing. I have had, I've been personally witness to such cases where the complainant has lost jobs. So this cannot be the outlook we have. That is why the internal complaint committee is required to be extremely fair, unbiased, and transparent. That is why there's a requirement of a third party to sit on the internal complaint committee, so that the aftermaths are not happening. Now, what is very important also to see is that this internal complaint committee, or having a POSH compliance being done in your organized setup, it is also important to see one aspect. It's not just the complaints. So you have to, the internal complaint committee has to also see, we have also come across cases where fake complaints were made against the senior employers. Now, that's one thing, because this act is also being misused at the hand of certain people. And I have been witness to such cases as well. So therefore, it is very important for these complaints to be taken seriously and handled in a very mature and a due process manner. Otherwise, it would be, it would be very difficult to ascertain. Apart from this, what is very important is to address the myths related to this WASH compliance. Now, I will address the myths that I have had a chance to address to my clients. So the first myth, King, which I have already addressed, is that because this startup consisted of only male members or only the male staff, so they thought that probably there is no requirement for them to have this compliance at workplace. So this is an answer to all the fact, and the act provision is that any organization with more than 10 employees, regardless of any and all genders, are required to constitute the internal complaint committee. So be it the fact that you are all male members or you're all female members, because the act covers the extended workplace, which also sort of include third parties into it. Therefore, it is required for you to have this internal complaint committee in place. The next myth that I keep hearing from my clients and people who approach us for this legal assistance is, so once the internal complaint committee has been made, so the work is done. So which means the compliance is done. The compliance does not end here. It starts from you constituting the internal complaint committee, and the complaints have to be resolved. There's a due process given in the act, and it has to be resolved according to that. So definitely the task does not end there. Now, the next thing that I also hear is that internal complaint committee has nothing to do with the third parties, which may actually exist or which may have been subject to sexual harassment by your employees, or who your employee may have been sexually harassed by the third parties. So the act covers the third party. So it is just to put this fact out, the organization must take necessary provision which allows your employees to file complaints against the third parties as well. And you can also take actions against the third parties. Then one more funny myth that people have is that the entire work of the internal complaint committee, there's a language barrier. So a lot of people have heard that it has to be done in one particular language, but that is not true. This is something which goes beyond the language barriers. This is a problem which goes beyond a particular culture or a community. So any local language, Hindi, or it is all acceptable. You have to work in an internal complaint committee. Language is not a barrier, believe me. The last myth that I also come across is that if the organization, because the act provides for 10 or more, so a lot of time my clients ask me that we are 11. So are we required to still use the internal complaint committee? Yes, you do. The act provides for 10 or more. So you have to constitute an internal complaint committee inside. And there's also a few things which are overlooked by the organization in terms of this act, which I am harping again and again, is the requirement of an external member on your committee. It is very important, and you will not be able to prove that your trial was fair unless until there was a external member available on your committee. So that external member could be a person from NGO who's been dealing with sexual harassment cases, or who's at least familiar with how this act works. It may not be a lawyer, but it should be a person who's familiar with how this act works. Then also it is important for the organization to have a handbook, to have a code of conduct inside your organization, which should specify to the employees, and it should be the part of your orientation itself. Once the orientation is happening, be it law firm for the newly joining employees or the interns, or a company, any disorganized setup, it is very important for you to have a code of conduct related to the sexual harassment policies and procedures at workplace. And every employee, so it may be an employee who's a cleaning staff, maybe not that well versed with English, and he will not be able to understand the kind of documents you will give him to sign. That yes, I have seen your internal complaint committee mechanism, I've seen the code of conduct related to it, and I agree and I've understood. You have to make them understand. You cannot just get signature and get away with it. There has to be orientations done, there has to be trainings and workshops conducted for these employees also to understand the nuances of the such acts and misconduct inside. And then lastly, there's also inclusion, which is you have to file an annual report. There has to be an annual report prepared for all the information and for all the cases that were complained, that the complaint against which were made, how it was resolved, what is the resolution procedure followed, what was the timeline. It is always best to document these things, and there has to be an annual report prepared so far these things are concerned. Apart from this, if there's any specific concern, Jay, I would be very happy to address that. But my intention is not to cover the entire act, otherwise it's a very broad, it would take the entire day.
First of all, congratulations, Mrs. Mishra. Your talk was outstanding. It was
Thank
glued
you.
to your talk throughout the session. And in fact, I must admit fairly that I had some 6-7 questions at the beginning of the segment, but then your discourse has probably answered all of them brilliantly.
Wonderful. That's the
Much
intent.
for that. And a couple of pointers that I wish to draw and mention and reiterate with that some really wonderful points that you made. Number one, the definition, the whole ambit of workplace has been expanded to the virtual sphere as well. Now, most of the interns, they're doing a lot of offline and online work, and online work in particular because of this pandemic. Now, so definition and this whole explanation has expanded. And now we have these WhatsApp groups that are becoming modes wherein work is allotted to them. So that is something very important. And the whole ambit has changed completely. The whole meaning, the whole interpretation of workplace has changed now because most of us are working from home. So even a lewd message that is sent on a WhatsApp app can be treated as and qualifies to be a sexual harassment act under the provisions of the act. Number two, there is something that is very unfortunate that I've seen in the state of Rajasthan over the years, that there are so many organizations, these reputed, prestigious organizations that still don't have this mechanism called the Internal Complaints Committee, which is required as per the provisions of the Act. Now, many a times there are these unreported cases of sexual harassment. Now, where does one go? Because there is no committee in place. How does one ensure formation of this committee in consonance with the provisions of the Act? Now,
I'll also tell you one thing which is very important and which is very sensitive. So anything related to a sexual harassment. So if there's no internal complaint committee or there's no designated person to whom you can go, what do employees expect if I happen to undergo a similar conduct and I want to report it? Do you want me to go to my immediate senior and report it? And because that is where the bias will come, the partiality will come, and then you would always be in a fear of losing job. Then you would end up just avoiding it. It's okay, like you will probably avoid the person, but it would not avoid, you can just avoid the problem. It's not solving your problem. So a lot of time we have also felt that because the internal complaint committee was not in place, there were employees who were ready to report it, but they did not had anyone to go, and they just definitely did not want to go to their bosses to report these things.
It is very unfortunate because the whole purpose gets defeated if the complaint is not made at the time when the incident takes place or the occurrence of this crime, which is very unfortunate for the whole fabric, that is so important to retain and to conserve. So thank you so much, Mrs. Mishra there. Our email is mentioned on the channel. So any of the queries with respect to this topic, feel free to write to us. We'll be happy to forward the same to our amicus. Now moving forward to our next topic, how does one approach recruiters, especially for law graduates who are watching? How do you approach them? It could be for an internship, for a job. Now, this is something that has probably been a mind boggler for most of us, because yet to come to terms with this fact that there's no straight jacket formula as such, or there's no perfect route or perfect way to do it. But then obviously through your experiences, if you can share and talk us through about how does one approach these recruiters? Over to you.
Okay, so this has been, I have to accept that when we were interning and I had an opportunity to also intern with you in one of the law firms. So this was something which was a problem which was not addressed as an intern to us, but once we actually reached the law firm and this was addressed then, and it was very embarrassing then to hear these things. So as an intern, a lot of internship application is received by my law firm every year and every intern season. And the common thing that I find in all the applications, which is of the importance for the law schools to also address, for the placement committees to have a session on that, is how they're approaching the law firm. And that also, as a law firm, once you're sitting and reviewing the application, and HR is sitting reviewing the application, the first impression really, really matters. It may be secondary or how good you are at the work once you actually select it. But what is at most important is how you're approaching that firm for application. So I will not discuss on what to do because that would be a big list and probably you all know it already. What I will address is what not to do when you're approaching a law firm for internship, or you're approaching a private limited company for your internship training or say job. The first thing which is very important is your email ID. You have to make sure that your email ID is really professional. You cannot have a email ID. Let me start the joke with myself. So you cannot have an email ID which says Preetika smiles at the rate gmail.com, or you cannot have an email ID which says XYZ is cute at the rate gmail.com. And believe me, these are the real email IDs I've seen and have received applications from these. So I will not take names. You cannot have email ID which says XYZ law internship at the rate gmail.com. Simple. Keep it your name. If you want to add some number to it, because you may not be, because that service provider, for example, Gmail already have a person with your name, you can probably keep a year to it. You can add your birth year to it. You can add your batch years to it. You can add the name of your law school to it or your law college to it. You can add all of that, but your email ID while you're making an internship or a job application has to be extremely, extremely professional. So when receiving receiving an internship application or job application from a email ID like that, it gives the first impression that you're not serious for your work. So that is the first thing, which is a strict no. The next thing is a strict no is when coming to the resume part. Your email should always have a cover letter, and your cover letter cannot have your entire resume in it. Your cover letter should have things which you may not have been able to include or incorporate in your resume, because your resume was supposed to be one pager or two pager, but your cover letter cannot be a summary of your and these are my personal views. It may differ from company to company. A company may require your cover letter to have a summary of your resume, but I personally feel your cover letter should talk about the traits of your personality, which would be useful for the employer to see. Or when you're studying, if you're applying for a specific job position, you should always read the eligibility criteria. And in case they have listed down an eligibility criteria and they have given out certain qualification criteria or the qualities they're looking in their employees or prospective employee, you should always talk about those particular points in your cover letter and how you stand on to the criteria they have mentioned, and because that thing is something you cannot talk in a resume. Your resume is made once and then you're going to forward that resume to all the law firms. So it is important that you are talking about that specific requirement from one job to another where you're applying in your cover letter. That is where you can use, and the cover letter cannot be long. So the first para, second para end, because no one will have time to read a cover letter which is a one-page cover letter or two-page cover letter, because they would also want to go to your CV. So your cover letter should be interesting enough for you and for your employer, to push your employer to open your CV and see what have you done. Like, such an interesting person, let's open the CV and see what he has done, what she has done. So that's how your cover letter should be. The second thing, which is a strict no, when you're writing, you're coming to resume part. So if I open the resume, a lot of people write objective, and it is good to write what your objective is, and it is very clear that you're sorted on what you want out of that job, because it is also important for you to convey to your employer what you're looking at, so that your employer also knows they're able to provide you that kind of exposure. Well accepted. If not, then they would at least be humble and they will say no to you. So that is what objective plays the role there. But a lot of time I have seen the objective statement to be written as, I want to be best lawyer, I want to be a good human being, that is why I want to intern or have a job at a prestigious law firm. I am sorry, my friends, if you're not a good human being by now, I don't have the responsibility of making you a good human being, and I'm definitely not taking you. Because if you're going to write your objective statement stating that your aim is to become a good human being in the field of law, then a law firm or a company is not there to make you a good human being. You have to become one and then probably apply so that that criteria is ticked. So you cannot write your objective statement. That could not be objective statement. It has to be one, a very professional CV. And a CV, anything more than 2 pages are always a lot of times not accepted. If you're applying for foreign internships, they always expect a 1 page CV. And there are number of websites and number of resources which are available on Google, which the interns can see and they can get help in drafting their resume. So I have also seen Harvard. There are number of CV samples which are given on Harvard's website, and the resources available from Harvard, which I had taken help. I'll be honest. So I had resorted to such resources and saw how well they're making their CVs in 1 page, and it highlighted everything that it had to highlight in 3 pages. So it was just not in sentences form, it was just pointers. It is very easy for the employer also to glance through it, because they are not going to give you a job on basis of a CV. The CV is just for them to shortlist you. They would obviously want to meet you. There would be number of interviews that would be held. So you would have a number of opportunities to impress a lawyer, tell them what you feel, what your objective is, why you want to join the particular company or the setup, the organization. You will have a lot of time, but your CV should be crisp enough for them to shortlist you in the first place. It cannot be everywhere. You cannot be a good person also. Your objective cannot also be to have a job. So it has to be very, very serious whenever you're approaching whether it's internship, it has to be taken as a very serious thing. Because if you're shortlisted, good. If you're not shortlisted, believe me, you're not shortlisted in that particular internship for good. Because once impression is formed, CVs remain in the system, and once your email comes back, people remember that you had already sent, and they had, a lot of time. I'm talking about the other side of desk. These CVs are also given as an example. See how you should not write the CV. So you do not want a CV to become example of that. The next big no that is there for the prospective employees who are applying for job or internships is when they're writing their CVs, they have to be very specific on the role. So if you're applying for a job posting that you've seen on LinkedIn or you've seen on Naukri.com or anywhere in any portal, you have to also read what the employers has asked, the eligibility criteria, like I mentioned. They would also say what the role is. If you look good for the role, if you see the role fits you, only then you apply. And then your CV should demonstrate everything that they've asked for. So in case you have 10 things, and out of that 10 things, it may be good on your merit. If only 3 things matches and adds on to your profile with that, you can probably skip the 7th thing and add something more. So use that space, use that 2 page or 1 page to, sort of change your CV as per and do not, when I say change your CV, do not write things, make things up. Write things which suit the employer. And the last thing that I want to tell is when you're speaking on phone, if you get a call from your employer or from a law firms asking you to appear for an interview or asking for your availability or time, it is your mannerism and your first impression that will be your first human contact on phone with the person. They will hear your voice, they will hear how you're talking, how you're addressing them. So that has to be thoroughly professional. If you're not able to speak, then if there's a background noise, you're not in so you can always request them that you will call back, you're in the middle of something, but do not take calls if you're not available to take calls. Do not take calls from place where you're not audible enough, and do not be unprofessional on the calls. That is very important. I have my HR has reported a number of times wherein they had called the interns or the prospective job applicants, and the job email said, "Hanji bataiye." So, and this is after them introducing who they are. So it is a good way to speak. If you want to speak in Hindi, please speak in Hindi. But your mannerism, the way you're speaking, the way you're addressing the person at the side speaks volume about you and your personality. And people are going to judge you on everything that you're doing. because they're going to recruit you on their pay. You'll become part of their company. You will represent that company or law firm. You will be the spirit of the company. So they cannot get it wrong. So these are the 5 things that I always address to interns who come and intern with us, and also to juniors who speak to me and who seek guidance on these things. These are the 5 things you have to make sure that you're doing 100%. But I'm sorry, the 5 things that you're not doing and you're following what has to be done. What you did.
Thank you so much there, Mrs. Mishra, for your valuable insights. I'm sure this segment, this second topic that you've dealt, is going to immensely benefit all the viewers who are watching, especially law graduates who are, who will be in line of applying to jobs soon. So thank you so much once again. And stay tuned. Next episode, it's on its way. Thank you so much, Ms. Mishra, for taking out time from a busy schedule.
Thank you, Jay. Thank you for the opportunity.
Thank you so much once again. It's goodbye for now.
Thank you.